and I'd like to call the February 24th, 2021 Broker Responsibility Work Group meeting to order. So I think we have 2 commissioners on today. I haven't looked at the whole list. I believe Barbara Russell is on, and Jan Fight Miller is also going to be joining our group, but I don't know if she's on this morning or not. Is she on?
I don't. Oh, this might be her right here, right?
Yes, I think that's her.
Just in time. Good morning. We were just introducing you. You're right in time.
I'm sorry I'm late, and I'm still not teleconferencing, but good morning, everybody, and I'm pleased that I can sit in on this meeting. Excited about it. I've watched your good work for a long time.
We are happy to have you. I guess we are ready to start new business now. The first item on the agenda.
Leslie, if you don't mind, I'll jump in on the housekeeping.
Please.
So just as a reminder, everyone, it's been a little while since we all met, is to mute unless you are speaking. That helps us with the background noise. And to really only use chat if you're having technical issues, to let us know. That way we can just make sure we have everything that's recorded for open meeting purposes. Hello?
Hello?
No? Okay. So yeah, if you can stay on mute unless you're speaking, and then just refrain from using that chat for anything that's substantive. If you have technical issues, anything going on like that, that's great. You know, use it for that and we can reach out to you. And that's all I have for housekeeping. I'll turn it back to you, Leslie.
Perfect. The first item on our agenda is discussion regarding overview of the November 2020 recommendations to the Commission and path forward. As we mentioned at our last meeting, I was going to meet with staff and Chairman Kessner about how do we go forward with our recommendations. Since this is kind of a strange year for the legislative session, I don't know if our recommendations are going to get moved up there or not. So we're kind of in a wait and see pattern, but I know the staff has been talking about some different options, which is great. When I talked to Chairman Kessner, we discussed our recommendation for military spouse and general portability. And those are kind of where my questions came from on your little survey and questionnaire. Chairman Kessner had really talked about some of the classes that we are requiring are taken elsewhere before people come to Texas, specifically law of contracts, which is different from our contracts course that we're offering now, our promulgated contracts. And he was also talking about law of agency, which is taken elsewhere. He did like an idea of everyone taking a broker responsibility course to know what a broker is responsible for, whether you're an agent or a broker. And he also discussed the Real Estate License Act class so people would know exactly what our state requires. So those are where a lot of our questioning came from this time. Chelsea, Vanessa, do y'all want to add anything?
I'll say a few things and I'll let Vanessa clean anything up that I mess up. It's highly possible. But Leslie, you're right. I think it will be, my expectations are very low for the recommendations that came from this group to get passed in a bill this session. But I do not want those recommendations to get lost at all. just historically, and as an outsider looking into the process, when there was a broker responsibility working group the last time, it was on the front side of session or of the sunset review process. I think that some of those recommendations really were lost because of the focus on sunset, and I do not want that to happen again. I'm committed to not allowing that to happen again. But I do think that that because of the session being what it is, it will likely mean that we build on those recommendations. Kind of if what we would like to see is the rulemaking authority to toggle education and experience. And so assuming there is not a bill that passes this session with that authority, what we'd like to do starting the summer is to start drafting rules that would be passed if we did have rulemaking authority. So that we basically had a complete plan in place as we go forward to the legislature next year. I'm sorry, not next year, next time. So we're committed to that, but I think my expectations are fairly low on making progress this session. This session, each member of the legislature seems very limited in what they are filing. And we were working with trade associations on moving things forward, but I think it's just likely not much will happen. I do think that the work of this group to put meat on the bones, I would say, regarding license portability and addressing the issues for military is exactly where we want you to be headed. And I appreciated the input provided on these surveys. Vanessa, what else do we need to say on that?
Yeah, no, I think you said it, which is we're looking at that rulemaking authority. Does it go this time? Does it go next time? Either way, there need to be some rules. And so that's something that Chelsea just mentioned. We can start looking at, we as staff could start looking at what rules would be implicated that are currently out there, and start bringing drafts to you guys for your review and your input as it relates to that education and experience balance. So taking the recommendations that you guys made, working through the drafts that we would present to you all, and really creating a whole package. Because if that rulemaking authority passes, that's a big rulemaking process, and you guys would be the group that works with us on that. And I think, I think we all sort of can flash back to our meetings from August to November. Those were some long sessions and some really good input, and we can fortunately now space that out a little bit, and really dive in, I think, in the way that, from what I've heard from members here, I mean, you guys really have some thoughts on this. And so that's something that I know is super important to get the balance on. And I'll be working on that. Abby Lee, our Deputy General Counsel, we're going to start that process, regardless of whether it comes to fruition this session or next session. So I think that's really important. And Leslie and I talked yesterday for a long time. We went through those survey results, and she's going to go over them in more detail, I know, and then sort of get a plan. Where can we head, right? So we've got the education experience. I think that's going to be a long-term thing that you're working on throughout. But what are some other things that you guys can work on now that, one, maybe feel a little bit more tangible, and two, that you also have an interest in, right? Because you all came to this group with some interest, with things that you wanted to work on, things you wanted to look at that you're really passionate about. And so I think we have the opportunity now, because we have a little bit more time, to do both. So Leslie will get into that a little bit further down the line. And I think probably the best way is what she and I talked about, is to dig into those survey results, and see what you guys are thinking. Let's really open it up more for more discussion, more brainstorming. I know before, there was a real push, and there's less of that urgency in terms of we're trying to get a recommendation to that meeting. So I think it'll allow for more discussion, more input, things like that. And then, after this meeting, we can work with Leslie on getting prepped and ready for that next meeting. You guys will meet again this quarter. This meeting is sort of your makeup meeting for last quarter, because you didn't have one. So you'll meet again this quarter, and that's when we can start really diving into what it is we want to work on. And I will hopefully stop talking for the rest of the meeting, right?
Vanessa, I want to rewind just a little bit and make sure everyone understands what rulemaking authority would kind of give us, because right now we have it for experience, from what I understand. We just don't have it for education. So if we got that rulemaking authority, we could go through with our ideas without waiting for the legislative session each time. So I just wanted to make sure everyone's clear on that. And you may need to clean up what I just said, but that's how I kind of take it.
So we have that rulemaking. Oh, sorry. Go ahead, Chelsea.
I was probably saying what you were going to say, which is just that the rules are an extension of our law. We have whole chapters of rule that are proposed in one commission meeting and then adopted or considered for adoption at the following meeting. That process takes about 6 months, unless it takes longer, but it can't take much less than that. But that's a much shorter process than a law change, which is when the legislature is in session and if the bill passes and that sort of thing. So it's by the legislature granting rulemaking authority, that gives the commission the opportunity to promulgate rules that we then enforce with the effect of law, with the force of law, I should say.
Yeah, that's exactly right in terms of what that process would be. I think it also it really allows for more people at the table. I really like rulemaking because you have people who are truly impacted by it coming to the table and figuring out, well, what works best for this industry, right? In terms of what we would be seeking, we have some rule authority when it comes to experience and determining active experience. Some of it is in statute, and then for education, it's all in statute, right? So we would be looking for a more broad delegation of that rulemaking authority to the agency, which, like I just said, would then allow probably for more stakeholder input. But that's something that, until we have it, we can't, we can start looking at what rules would be impacted and things like that. And that's what we'll start to do in preparation. But it would really give this group that opportunity to weigh in on what those rules would look like.
So I guess we're ready to dive into our survey. And
you have
one
question. Yeah.
Just to clarify, so you said we have rulemaking authority for experience, or you guys do, the commission, right?
We have some, right? Some of it, it's like some of it's in statute, some of it's delegated by rule.
So the recommendations that we made on experience, does that fall under that, or does that have to all go through legislation?
So the thought is, what we would do is we would get that rulemaking authority to be really clear for both education and experience. And then we'll take those recommendations, and you guys are welcome to revisit those recommendations and toggle them a little bit more in this interim, and then we can start looking at where those would plug into the rules. That's something that we'll start looking at immediately, just to see where it would fit and how it would go. Does that make sense? Okay.
Okay, Y'all ready to dive in real quick to military spouse licensing? And that was kind of, we were talking about 50% of what is required, whether it's our current requirements or our proposed requirements. And so part of what we had discussed formally was adding the law of agency and law of contracts for their Texas-based required courses. And so it sounds like from this survey, and some of the people did not answer, we only had 6 out of 9 responses. They agree that we could take these Texas-based classes out, the law of contracts or law of agency. And I mean, they still would have a promulgated contract class. But we also said that we could add a broker responsibility class, and everyone was split on creating a new class for the Real Estate License Act. So that's where we stood with military spouse licensing. Does anybody have any discussion? Yasmin, your hand's still up. Is that just from before? Okay. Does anybody have any more thoughts on that?
This is Jan.
Go ahead.
Jan Miller has a question and a statement.
Yes, ma'am.
I kind of speak for the commissioners who had voted this, excuse me, had voted this down at some point. Excuse me, just choked. We have a problem with having to enforce geographic competency, and yet a trailing spouse can, and I don't know how you judge it just from military. What do you do when they're not just trailing spouses anymore? They decide to stay here when spouse went somewhere else. So you face those kind of issues, but we are assigned to enforce geographic competency. I mean, and that's been very clear through several, 2 legislative sessions. How can we do that to somebody that just got here? And I use the example, I live at a lake and I shouldn't have bought here without knowing more. And I certainly would not be selling property around here because there's too much to know about stuff like that. And how do we expect a brand new person into the state to be able to do that and enforce it?
And then Chelsea, I think you could kind of fill this in, but from my understanding, this is a Texas-based law across all agencies for the most part that we have to offer military spouse licensing. But I also believe this is only a 3-year license, so it's pretty temporary. Do you want, Vanessa or Chelsea, do you want to add anything to that?
I think that's exactly right, Leslie. So what we have is there's a statute that's passed that requires that military, specific to military spouse, coming in and they can, here we would, at Trek, we would grant them a license, and I don't know if Denise wants to speak this a little bit more, but in terms of being able to actually practice in the state, they get that from us, but the statute itself allows for them to come in so long as there's a substantial equivalent component to their licensure out of state. And that's been a little bit of that's been the conversation, is what is that that difference when it comes to geographical competency. I think the argument has been we can't impose a new requirement because of that statute, but can you do it through enforcement, right? If you have complaints that someone's not meeting that requirement, yes, because they still have to meet those guidelines. And you're looking at substantial equivalent, you're looking at adding these classes, so maybe these Texas-based classes, maybe there's some room there. And then it is a 3-year it's limited. So if they decide to stay here, then they'll have to go through the process of getting that license. It's not that military spouse license. If I'm not saying that correctly, Denise or Jennifer, remind me. I think I have slept since we've had that conversation.
No, you've captured that correctly. That
Okay.
you know, we have to issue. Well, I think we don't have to issue a license. They have the authority. We just have to define the substantially equivalent part, if I have that correct.
Right.
You were right about the time limit as well.
Okay, and we do issue a license for purposes of tracking and MLS and things like that, right?
We would, because
Right.
it wouldn't be beneficial to that person practicing in Texas without having a license number and a way, you know, to access the MLS and be listed on our website and all of that comes with a license number in our system.
Yes. But again, so what we're looking at is that definition of substantial equivalent, which to this point, Denise, if I'm correct, we've had a pretty high measure of what substantial equivalent is, based on the education experience requirements that we currently have, right? A prior interpretation.
Right, because we haven't defined what substantially equivalent means, so it means almost equivalent. So the 630 related plus the 270 qualifying. Right.
And so this is we're thinking this is a small group of people, right? Because it's military spouse. But in looking at, I'm actually just also trying to remind myself of all the conversations that we've had as I say this. When we looked at substantial equivalent and making a recommendation on that, we looked at this idea of adding Texas classes, right? Because we had such high number of hours, but if we brought that percentage down, but then we had these Texas-based classes, you start to get a little bit more, hey, here, this is Texas specific. Here's what we do in Texas. And I genuinely can say, I don't know if there's room in there to address I know you can't address the specifics of geographic competency to each area, but the importance of it, or I'm literally just saying words right now about that, but things that you guys can consider that are important, because, you know, as Commissioner Miller mentioned, this is something we hear a lot about as geographic competency, but we're also bound to this specific statute when it comes to military spouse. I think your wiggle room lies in substantial equivalent and the agency getting a definition of that works. And if I have misspoken, please correct me.
Now, I did just want to add that for the screen that Amber has up shared with everybody, that number 3, she just took it down, sorry about that. The question of would a 30-hour Real Estate License Act class be beneficial, you know, to include in the requirements. And I just wanted to reiterate that Principles of Real Estate 1 does include 3 hours on the Real Estate License Act.
Leslie?
Yes.
It's Bob Baker. How are you doing?
Good, thanks. How are you?
I'm good, thank you. I do want to visit about number 1. I understand that we're still recommending promulgated contracts, so that's maybe why we're taking law of contracts. But I'm not sure I understand the thought behind taking law of agency, since agency is treated so differently in different states. I would think, I mean, we have a challenge in our offices when people come from another state and they have such a totally different understanding of how agency works in Texas versus how it worked where they came from. I'm concerned that if we don't have something to help this trailing spouse to understand agency in Texas, that could be a challenge.
That's a great point. Thank you.
I just wanted to add that I was one of the ones that thought we needed to include that for that same reason. It's completely different.
Yes. Hello, this is Soccer, and I agree with Yasmin. We said that we wanted them to take a law of agency class in Texas, a Texas law of agency class, because our agency is so different than everybody else's. So that law of agency needed to be a Texas course.
Brian, did I see your hand a second ago?
Yeah, I had a comment about the geographical competency, but it seems like we moved on to the law of agency. But with regard to geographical competency, I think it's a really tough thing to measure. I mean, if I'm currently licensed, but if I moved to another location, if I moved to the DFW area, I don't think there would be any requirement for me to demonstrate geographical competency. I'd be allowed to practice. And so that would kind of create an unlevel playing field. Another example would be a new licensee, an SAE, just getting their license. They would be allowed to practice, but do they really have geographical competency? So I think it's just a tough question to build a rule around.
Anybody else?
This is Soccer again. I agree with geographical competency. I think that's gonna, we're the broker responsibility work group. I think that's gonna fall upon the brokers, because I have an agent in my office who lives and works in Austin, and she wanted to go and represent someone in Johnson City. And I said no, because she doesn't know Johnson City. So because of geographical competency as a broker, she wanted to list the property there. So you don't know what's going on in that community. No. So she referred it out. But I think that would actually have to be enforced by the broker, and then only the commissioners and the commission would get involved if there's a complaint or something. I don't know, but it is hard to police that as a broker and as a commission.
Leslie?
Yes, sir.
This is Bob again. I seem to remember when the recommendation was made by the previous working group on geographic competency, and it got to the commissioners, and at that pre-COVID public meeting where we were there, it seems to me that I remember Commissioner Miller, Jan Fight Miller, as they approved this, smiling as she looked at the other commissioners and say, you just need to know this is going to be really hard to enforce, to Brian's point, and to the other point that this is really going to fall, as Soccer says, to the brokers. But we're going to have a real challenge in doing it. But I think if we require the broker responsibility course to be taken by these trailing spouses, that's covered in that course. And it really is going to be up to the brokers who take on that trailing spouse to say, okay, here's what you need to know. And the broker's going to have to police it, because this is going to be hard. I mean, we're clear they're going to be test cases. We don't want to be one of the test cases, but it's going to happen because it's in our expanding regional MLS. I mean, our MLS in the Dallas area covers Abilene. How many people in Dallas are familiar with Abilene? I am, because that's where I started, but otherwise. So I think it's going to be very hard, but I think it's very important for someone coming into our area to understand this is a requirement, and it's not just a requirement because it's a rule, it's best service to our clients.
Right, which is good news too. Part of this is that if nothing does happen during this session, part of our agenda or our next steps is discussing the broker oversight and discussing the competency requirements. And we definitely would have geographic competency in there. So all of that could be factored into our recommendations if we get rulemaking authority or for the next session, however that works out. Yasmin, did you have something?
Yes, I just wanted to, I guess, offer a suggestion. I know we're going to talk about this a little bit later on mentorship programs, but I was just thinking for like a military spouse, maybe we could have something like a mentorship program where they have X amount of transactions that they have to be completely supervised under the broker in order to help with the geographical competency and with just all the knowledge in general. So I just kind of wanted to throw that out there for discussion.
Perfect. I think that's a great idea.
And I'll just mention one more time, because we'll keep having to go back to that statute, right? The statute allows the military spouse to come in and practice once they have that substantial equivalent layer met. And so we can't do anything that goes against that statute. You know, we can't increase it. It says that they can practice if they meet that substantial equivalent. So I think that's why looking at those courses, which I think it was Bob maybe, or I think it was Bob was just mentioning how some of that is encompassed in those required courses, right? So I think that's where you're going to get the substantial equivalent Texas component of education in there. But we just need to, I'm going to keep saying, oh, but we have this statute. So just, that's why I'm going to keep saying that, because that's what actually tells us what we have to do. That said, though, there's also a component of outreach, you know, agency outreach, things like that, that can be done, guidance that can be given for folks that are coming from out of state under this military spouse, things like that, that we can talk about, that don't necessarily put a limitation on the statutory requirement, but that make more information available. Just things like that. So I'm gonna keep bringing up that statute, and I'm not doing it to be annoying, although it probably will be annoying, but just as a reminder that, you know, you have these other avenues, you have those required courses that you're thinking about when it comes to substantial equivalent. So I think that's right on the money. I just want to remind you guys about adding requirements that we can't do via statute.
Sorry, just to clarify, Vanessa, so you're saying that due to the statute, we cannot add a requirement of mentorship?
I don't think you could with that statute, because the statute says they can practice once they meet the substantial equivalent. And the way that we've been talking about substantial equivalent in our last meetings has been, okay, a percentage, and then there was this idea, and I really like this idea of the required courses. I can't promise that's a new way of looking at substantial equivalent, and I'm not sure necessarily where it will go. I like it. I think it seems like everyone's on board with that idea of sort of required classes to get to that substantial equivalent. But once you start adding more than that, we're really getting outside of what is substantial equivalent. I don't think it is in line with the statute.
Jennifer, did you have something?
Sorry about that. I just wanted to reiterate a couple of things I've heard, and then provide a little bit more information. So, like Bob and Vanessa said, there is a component of geographic competency in the current broker responsibility course, and that's the non-elective 6-hour course. Additionally, just as an FYI, the 30-hour real estate brokerage course, ESAC is probably going to take a look at that, because the content of that course currently is really about business building and business operations. And they might be looking at that to make that more aligned with a true responsibility of a broker and responsibilities to sales agents that they sponsor, and to include an element of geographic competency and all of those, you know, expectations. So that's just an FYI that's something that ESAC is going to be considering. And then lastly, just regarding the agency, the law of agency course, our course content outline for that does include references to the Texas statute. So in establishing whether or not a course that somebody took outside of the state is equivalent to the agency course that we have, you know, I think I don't know that it could be determined as equivalent, just because we have state references in our required course outline. So that's all I wanted to just add.
Perfect. Bill.
Thank you. I'm a little bit confused. I'm sorry to be such a slow learner here. There's two aspects here of the spouse licensing. One is as a broker and one is as an agent. Is that correct?
I believe so. You want to, Vanessa, do you have any more?
So my question is, substantially equivalent means it's substantially equivalent to the license that you're trying to get under, right?
I believe so.
It's not. So where I was, and it was where I was going to go with my question is, to handle a lot of the insecurities of how you practice and what you're doing, would it be possible, and maybe that's what somebody said about mentoring, would it be possible to create the requirement that a spouse could come in with the 50% requirement on the education hours, but that they have to be, that their qualified or provisional license or provisional permit to practice has to be under a broker, a Texas licensed broker. And I don't know if that's what somebody was saying, what mentoring means, but that way you've got somebody who can really help these folks understand what the rules are, monitor what they're doing, help them create some touchstone for resources for information and education, and to help them navigate through the process. As an agent, that's already required anyway, I think. But the question would be, as a broker, if they're coming in as a broker, could we make that a requirement to just say, look, we're going to let you do it, but we just want you to be supervised by a broker that's licensed according to everything else. And maybe, and I don't know if I'm really getting out of sync, but to make a different classification of a permit or license for these particular folks that just says, yeah, we'll let you practice, we'll let you do your work, we'll let you come in under the 50% rule for these various things with certain required Texas courses. But part of that requirement is that you have to be supervised by some kind of by a Texas licensed broker. Just a question, and I don't know if it complicates the issue. The other thing is, I think somebody mentioned early on, I think we're talking about 2 people a year that we're spending hours on this thing for 2 people. And I understand we have to do it, but it's the question is there a way to create an exception process or some kind of a process which allows these people to get in? And I seem to recall that there was some kind of a discretionary provision in the Texas Real Estate Act or somewhere that said that the commission has the right to make discretionary waivers for certain particular situations. And I'm wondering if that's something we can hang our hat on to sort of accommodate these very few situations.
Vanessa, do y'all want to add something?
I'll add a little bit, and Bill, I think you're asking, both of your questions are questions that we're seeing on this, especially when it comes to that idea of like a mentorship relationship, and then I'll tie it back to the second issue of how many people it is. When it comes to military spouses, we are more limited because that statute, it says that they, as long as there's that substantial, they're licensed in good standing in an area that has licensing requirements that are substantially equivalent, they can practice, right? So we can't add to that. We can't add that requirement of you must have a supervising broker over you or a mentorship. We can't do that for this group of people. Statute tells us exactly what we can do, and the point of that, right, is these are spouses that are coming in under military orders of their spouses, and then I think the governor's office is trying to help them, recognize what they're doing and get to work. Where we have some flexibilities in that substantial equivalent, we don't want that to be so high as it's a barrier to entry for this group. I know from all of our conversations that we do want it to be a measure that works, so that you have people who are practicing in your industry that can meet that equivalent of what we're seeing in Texas. To your second point, yes, it's a more limited number, right? And to some extent, well, why, if it's such a limited number, why are we having, as much conversation on it? And it's because we want to get that substantial equivalent definition. We want to get something that works. I know this is important to the governor's office. It's also just important in our obligations with having this statute in place. But I think that substantial equivalent is going to carry over too when you get into your conversation about portability. In portability, do you have more flexibility? Yes. Do you want to keep your definition of substantially equivalent close? Probably. But I think you do have more flexibility there. But when it comes to military spouse, we really can't add barriers to entry. They've got the authority to practice so long as they meet that substantial equivalent. So I think, and I said this before, if that addition of those required courses, if that passes, that's your flexibility under the statute.
I have a question, actually, probably because she mentioned Principles of Real Estate 1 had a 3-hour real estate license act component, but military spouse licensing, that wasn't part of their requirement. It was really just Texas-based courses. So would it be a good idea to add that to what they would need to take, if that would be possible?
Leslie, was that question for me? I may have.
I
don't think that I caught that.
Talked about Principles of Real Estate 1.
Right. It has a.
So the military spouse, or as we have it for, I think, going both ways, whether you're coming to as an out-of-state applicant or military spouse, I don't know that you have to take principles. So would it be a benefit to add the Real Estate License Act or a class like that?
I can probably help speak to that. I think, principles in general, principles 1 and 2, most states require something very similar. The only distinction is really that our principles course does include that 3-hour component of TRELA.
So going back to our military spouse licensing, if we don't have our principles as part of a requirement for the additional courses, would a Real Estate License Act class help the competency of these agents? Anybody?
I think it certainly could, but I think.
Leslie, could I ask a question kind of on this, but really follow up to Bill? This is Bob.
Sure.
Okay. And I'm trying to wrap my mind around the substantial equivalency conversation. But to Bill's point, if someone comes from another state and they have a broker's license and they want a broker's license here, wouldn't their substantial equivalency require them to meet what we require of brokers here? Is that not the case? So if they come for a broker's license versus a salesperson's license, says substantial equivalency deals with our requirements for that level of license here, or am I totally misunderstanding the substantial equivalency issue?
No.
I think what we had discussed, and it was also in the survey, was if they don't qualify for the broker's license, they could be offered an agent license until they do qualify.
Okay, to that point, it would seem to me to kind of semi-solve Bill's question. I think it would be very difficult for someone coming from another state to meet our broker substantial equivalency, and that it would almost be automatic that they come in with a salesperson license, which means they'll be under a broker, which would solve a little bit of Bill's concern, which I think is a very valid concern. I think it'd be unusual for someone coming in from another state to be able to qualify to be a broker. It's going to be automatic, given the timelines we're dealing with, that they're going to have a salesperson license. That makes sense.
I would have, Bob, and this is more for staff, is if we're allowed to do that for military spouse. I think we could make that requirement for an out-of-state applicant if they're not a military spouse, but I'm not sure what statute requires for military spouse.
Right, Leslie, and that's, if we're just looking at military spouse, it's license to license, right, with that substantial equivalence. So is a broker from, I'm making this up, Arizona trying to be a broker in Texas, then under that statute, so long as they are licensed in Arizona and have a substantial equivalent, you know, they're substantially, that license is substantially equivalent to Texas, then they, under the statute, they can practice in Texas. Now, the question comes up, and Bob, you're bringing it up, right? Which is, who is substantially equivalent, right? And the position that I think was previously taken was that there's no one. There's no one that's substantially equivalent, and I think that's what this group has been looking at is, okay, that doesn't seem like an answer that works in terms of, you know, just no one can get in under this statute that was passed with the purpose of or the intent of getting these military spouses to work. So what could we as an agency do in terms of looking at substantial equivalent and getting them in? I think it does have to go back to your original question. It goes broker, you know, out-of-state broker to in-state broker, sales agent to sales agent. Certainly you could have somebody, you know, switch from broker to agent, but I don't think you could just say no one gets in under the broker requirements. There is no substantial equivalent. I mean, it has been said, but I think what we're trying to look at is how can we get to a place where out-of-state brokers can come in under that provision. So it's all going to go back to that definition of substantially equivalent. And it's why we keep talking about it. Denise, I don't know if you have something better to add than what I just said, though.
Yeah, I just wanted to add that, you know, you're exactly right, that because no one else's requirements are substantially equivalent, basically no one can come in under this statute, which is, you know, not okay. That's what we're trying to fix, I guess. But we also, because we don't have anyone that really comes in as a broker from another state, they have that huge stumbling block of the 900 total hours to meet, that we don't really have a way of tracking how many we've turned away and said, well, you can apply as a sales agent, because then, you know, you come closer to the requirements for a sales agent, even though you're a broker in the other state. So I, you know, just wanted to address, I think there was a comment earlier that we're talking about 2 a year. Well, we don't really know, you know, we don't really track them because they don't come in, they don't qualify. So we're providing them information. We usually direct most of them to apply as a sales agent. So it could be more than the number that was thrown out there earlier.
Right, that's true. I think we just know it's not what we would expect in terms of overall portability.
Right.
Right.
Phil, did you have another question?
Just a clarification. So what is issued to a spouse? Do they actually get an actual license, or is it just a letter that says you're permitted to practice real estate, or does the TREC actually issue a license to these folks?
We would. The statute does say that the only thing that the military spouse needs is approval, some kind of notification from TREC that we've authorized them to engage in the practice because we've verified their out-of-state license and that it's substantially equivalent. But just for logistical reasons and the ability for that military spouse to work in Texas, we would want to issue them a license number in our system, so they're displaying on the website. They can access MLS. Anybody can look them up and see that they're authorized to engage in the practice.
So as a broker, they could hire agents. They could set up an office. They can do all the things that a broker does. It's not just that they're selling real estate or buying real estate or doing stuff. They could actually operate in a brokerage capacity and mentor, supervise, organize, and hire people to work for them.
Right, and I believe that's the intent, is that a military spouse can engage in the occupation for which a license is required without obtaining that license, if they're licensed in good standing and meet the substantially equivalent requirement, which is what we're trying to define.
Yeah, I think we got a big problem here, because somebody coming in for 1 year or 2 years or 3 years with limited experience, limited knowledge. I think this is this is a complicated issue. And if there's not a way to create the definition of substantially equivalent to include and I don't know what substantially equivalent is legally defined as, but if there's not a way to create a substantially equivalent, means that they have basically the same experience and rights and knowledge base and stuff. It would seem to me that we should have some ability to modify that definition, even with the statute saying what substantially equivalent is, to allow us to create a license. It doesn't have to say it's a broker, it doesn't have to say it's a agent, but that it's a spouse license. I'm being very clumsy in how I'm saying it, but there's got to be a way around giving full rights to do everything without having all the requirements for a broker who's coming in, who's got to start fresh from Texas. It's just, I'm really conflicted with this. I'd like to accommodate these folks. I want them to be able to be able to practice. I'd like to make sure that they don't stub their toe, but there's something really missing here, and I don't know if anybody else has the same anxiety about this that I do.
So I understand exactly what you're talking about, and I think now that our initiatives probably aren't going to be addressed in this session, that we have more time to discuss this later. And I think we're also going to get into that with competency and oversight and all of that type of thing. We can also discuss, again, knowing these facts, what substantially equivalent means to us in this regard. So I think we can definitely have this in a future meeting and discuss everyone's concerns. As for now, I think we all agree that law of agency should probably remain as a requirement, and just circling back around that we do not have a principals class as part of the requirement. Would we be interested in looking into a Real Estate License Act a little bit more in the future? Would that interest anybody? I see some heads nodding.
Yes.
Okay, we can put that on our agenda too to discuss that.
This is Jan Miller. Can I ask you another question?
Yes, ma'am.
Or assign a task to the staff, if you could do it. It sounds like the License Act may be crossed with the governor's decision about what he wants the overall licensing in the state for nurses, doctors, whatever. to be. And I know that this has happened before between DTPA and federal law regarding fair housing issues. TREC got around it some way or another, and if you could have staff research that, what those directions were a long, long time ago, there may be a way to do it. And I think changing the License Act may be what it has to be. But another question is this group willing to soften the education requirements for the state, for anybody? Because go ahead, sorry.
I'm not sure if you read our recommendation or not. So we had lowered the education hours, but we had upped the experience because we felt like experience was really important prior to having a broker's license. But we did try to bring those 900 hours down a little bit.
I'm sorry, I did read it back before the November meeting, but I have not read it lately.
So I'll speak to Commissioner Miller just for a second. We can absolutely look into that, Commissioner Miller, and we'll do that. And this goes to that question of experience and education, and also I think what Bill's getting at here, and that I feel a little bit of relief on, is that we have a little bit more time to look at substantial equivalence. We can really dig into this input and put it on the agenda for a more robust conversation. I know Leslie's just kind of going over these slides right now as a dive back in, but let's do that and know that we're always going to have to go back to that statute. But that substantial equivalent conversation, it leads into license portability, right? I think education comes in there too. Generally, I think all of these topics end up being really related, and we've got the time to stretch it out and to really dig into it. You know, as an agency, we've got to look at the statutes that govern us. We take our direction from the commission, and we will we look at the recommendations that you guys make. So we have that time, the collective we, right? But we will look into that question, Commissioner Miller, and I think this is where Leslie was headed, so I'll turn it back to her of you know, let's make this that ongoing conversation that isn't so stressed out in terms of trying to get to November. I don't know if anybody else has the memory of that I do, of just trying to get to November, right? So we can really hash it out now.
Perfect. I think, and we definitely have the time. So, and all of these points are really great to bring to the table, so we can put it on our future agenda. I think right now, let's just start moving through these slides, and we'll take notes of what we need to discuss further in the future, and then we'll have our little path to where we're going. So I'm just going to move to the sales agent education. And when I talked to Chair Kessner, he thought that real estate finance, and we both discussed real estate finance could be part of renewal if we wanted to. But seeing that Denise mentioned that the Real Estate License Act is really covered in principles of real estate, if you believe that it's covered well enough, we just may leave well enough alone from what I see. But I think we've all thought about it. Would it be a good idea to add a broker responsibility class for all applicants and all licensees, because it does say what brokers are responsible for and what they should expect from their broker. And I think from the people that we discussed, we all kind of agree with that. Is that the case? Okay, good. So I think that is a good one to go by. Does anybody need a little break at the moment? Do we need, or are we good?
Break, please.
Okay, let's have, is 5 minutes good? Okay, see you in 5. I think we can go ahead and go. forward, we're going to talk about non-military reciprocity and portability. And what I wanted to remind everybody in this discussion is that the difference between reciprocity and portability. I felt like some of the surveys kind of suggested that there may be a little bit of confusion between the two. Can everybody hear me okay? Okay. Reciprocity is really dealing with an agreement between the two states. So the staff would have to go and find states that are substantially equivalent to us, which at this point we know is not the case. There's not one, and make an agreement for how that would look to be able to accept licensees, either going both ways. So in the past, we had decided that portability was a little bit easier for us to do because we could possibly take some of the education they've already had and the experience they've already had and apply it towards a Texas license. So I just wanted to make sure everyone understood that difference between reciprocity and portability. Reciprocity is a little bit more of a drawn out effort than the portability would be. So with that said, I'm just going to move through these slides real quick. Does anybody have a question on the difference between those two? Okay, good. Okay, so we talked about, this is where I think people were a little bit confused. We talked about, should we have licensing agreements with other states, which was defined as reciprocity. And some of us felt that, yes, we should, and one was not sure because I don't think they were sure about if we were talking. So in the October meeting, we all said that agreement should only be with states that have substantially equivalent education and experience requirements. As we know, that's not the case. So it's kind of going back to saying we should have portability versus reciprocity. The next question was, should this process or the portability process be considered kind of the same as military spouse and use the 50% rule as substantially equivalent? It seemed like people thought that should be the case. I don't know if per our discussion today, if you still feel that's the case or not, but it's definitely something we could talk about. In my mind, and I don't know if y'all agree with this, we could take courses if they are equivalent to our courses and apply it towards a Texas license. And they would be responsible for the rest that they haven't taken. But that would be up to you if you don't feel that they should take all of the courses that we require in some way or fashion, whether they have them before and they can be applied and they take the rest, or however you want to see it. But I think that is something that we need to discuss as well. Does anybody have anything to add to that? Okay, we all agree that all applicants should have to take the state test. And this was unanimous in October and now as well. I'm going to kind of go on to the kind of go back just to the summary and the conclusion, so we're not going through all the questions that you see on your screen. I know that some of our members weren't sure in the survey if we were talking about military or non-military. This again is non-military. So we're talking about reciprocity or portability for non-military applicants. So for what I understand that we're going our members feel like more going towards the portability route. So we're going to talk about that. So does anybody, let me go backwards because of our answers. Does anybody still believe we should have reciprocity versus portability? That's our major one. And I can't see everybody's head nods. So if you do think that we need to discuss reciprocity versus portability more, or using reciprocity, please put your hand up because I can't see everybody. Okay, so it looks like we're good with portability. So then we're going to have to define what that portability will look like. Do you think if we use portability, should they only be credited with the education that is equivalent to ours and have to take the rest of the courses, or do you think they should have the same 50% or whatever we come up with as substantially equivalent like military? Yasmin?
I'm sorry, can you, I know I said I was clear, but can you re-explain portability?
Portability is more towards being able to bring a license over without the state having to negotiate agreements with other states that are substantially equivalent to us, which we know nobody is substantially equivalent. So portability could be a little bit more defined by us of what the requirements would be to bring their license over. Sometimes I think of it, and I could be wrong and staff can correct me, I think it is almost like an education waiver. Like they can take what they have there, if it's equivalent to ours, and apply it towards their Texas license. And then either we dictate what classes they'll still need to take, or if they're required to take the rest of the classes that are set out for an applicant, whether they're not coming from another state or not. So the difference is whether there's a contract with another state, so to speak, or if we're just allowing them to come in with certain rules.
Okay, so the portability is like, we'll give them credit for some of their stuff kind of deal, right?
Correct. It's however we define it, but the state and the staff does not have to go out and make agreements with other states in order to implement people coming from state to state, if that makes sense.
Right, that's exactly right, Leslie. And I think we've talked about it a little bit, that portability is a smaller hill than oh my gosh, reciprocity, thank you. Because it doesn't require those formal agreements. Those agreements are individual, with each individual state. There's a lot of oversight above us that goes into those just because they are formal agreements with states. So I think portability is generally where you land. I do it too. I interchange them conversationally. But I think this group has generally seemed to lean towards this concept of portability. You do have on the line with you, and I know we've talked about it a little bit before, but you've got Jennifer and Denise on here who can talk a little bit about, how out-of-state stuff is currently handled, that idea of a substantial equivalent, making it a little bit more streamlined for how we do it, things like that. So you're welcome, if you want to use them as resources, they are here for you. If you want to hear what they currently do and just thoughts on that, I'll volunteer them for them. Okay.
Jennifer's hand is up. Do you want to add something?
Sure. Excuse me. I just wanted to add that a benefit to license portability allows us to review these on a case-by-case basis. One of the more restrictive components to reciprocity is that we would be required to continue to monitor requirements for other states to ensure those requirements haven't changed, and I think that would be a little more complex. But I'll also defer to Denise for her input.
Yeah, I agree with what you said, that the portability setting what substantially equivalent means doesn't require us to kind of keep, and we appreciate that research, Leslie, that you did, last fall of all the different states and what they require, but trying to keep up with when other states' requirements change and making sure that we have the most up-to-date information would not be as efficient as kind of setting, percentages plus, certain number of courses.
And this is Brian, and my question is, and just want to make sure that I understand it and rewrap my head around the difference between the two. In my mind, portability would be a licensee licensed in another state relocating to Texas and bringing that license with them, while reciprocity is somebody who's residing in another state but allowed to do business in Texas because of an agreement between the states.
Correct.
Okay, I have a question, please. Back to a slide that talks about license portability definitions, and we get to the 3 types of states.
Mm-hmm.
I'm not sure I'm clear on if what we're talking about doing, where we say, here are courses that we determine that are equivalent to ours, and you can bring those with, but here are the additional. It seemed like, for example, the TERP state, none of this would apply because their rules are such that it won't ever, their people won't ever be able to do this portability with another state except what's listed right here. Is that right? I'm trying to understand these 3 levels of states and the portability definitions.
At the moment, it seems like, if I'm understanding your question, and obviously staff is better to answer this, but it seems like at the moment, and with what our survey was talking about, is somebody could do business here, or they really can't do business here, but they can get a referral fee, but not a commission. And the referral fee would have to go through their broker wherever they are. So you cannot do business in Texas without a license and get a commission. You would have to only get a referral fee. Is that what you're asking?
Well, kind of, but I'm trying to get a sense of the cooperative state versus physical location state, and Leslie, maybe the physical location thing is what you're talking about. So I thought from what I heard from Brian that we're looking at the difference between people bringing their license here. Portability means they can take their license from Arizona and they come here with their license, and once they meet our requirements, they physically are here and can practice here, as opposed to still being in Arizona and doing a transaction here. I'm not sure which one of those we're talking about.
They would have to have a license here to receive a commission here. So if they came here portability wise, they're coming here to get licensed, is how I understand it.
Okay, so they'd be doing business here because they've moved their license here, and they receive credit for some courses, some experience, some things from Arizona, but now they have additional ones that we've set forth. Say, when you come here, you get credit for this, but here are the additional ones you have to take.
Correct. And
Yes.
what I understand, in Texas, you can have a license in Arizona and Texas, but I mean,
Sure.
you have to have 2 different licenses, obviously.
Yeah.
But you would still have to meet our requirements.
Okay, thank you.
The way Bob, like I said earlier, the way I kind of think about it is almost like an education waiver. So if you have taken a class that's equivalent to one of our classes and we feel that it meets what you need to know to work in Texas, then it can count against what you're required to take here. So it just kind of takes down those hours a little bit by using stuff they already have.
Okay, thank you.
Anybody else? Does staff have anything to add? Brian, your hand's up. Do you have something? Okay. Staff, do you have anything on that? Okay.
Hey, Leslie, Chair Kestner's actually joined us, and I think he was going to provide some input. I know that you guys talked about this in your in your meeting with him in December. So he had mentioned maybe having some input on this topic.
I would love it. Go ahead.
I don't know if you heard me say that.
We're taking him by surprise. Chair Kessler, are you on? Maybe on mute.
Hold on one second, everybody. All right. Well, we can, I'm sorry, you can repeat your question if you want to. I just, I know he's here. Oh, cool. Can we, I don't know if we can, I think he's muted, and can we unmute? I can't remember that.
No, we can't, we can only mute. We can't unmute.
Okay. That might be the issue, Chair Kessner. We cannot unmute you. He's texting me right now. Yeah, someday, you guys, we will not have these constraints. He's gonna call back in just a second.
So while we're waiting, let me just kind of ask this as a question, and then it's hard for me to. Oh, okay. So if we go this portability route, do all of us agree that we could? First question is, could we add someone's current education hours if they're substantial, or if they are equivalent, not substantially equivalent, if they are equivalent to our courses? Can we use that to offset some of their hours? Do we all agree that that would be okay?
I do.
Is there anyone that does not agree? I see Bill's hand up.
I agree. This is soccer.
I was agreeing.
Okay, so we agree that those hours can be used. Do we think that it should be all of our education hours, or should it be whatever we put for military spouse? May it be 50% or whatever it is?
I think it needs to be completely different discussions.
Bill, you agree?
No. No, I think the military spouse is an exception. I think if we're talking about allowing a person to come in and actually get a license, and if portability means they're really going to step into a Texas license position, then they have to have the same education requirements and experience requirements that we're requiring anybody locally. To that extent, if they've got a course or coursework, just like in college, you get credit if you go to one university and you got an economics course, you can get credit for economics. It's whatever it is. I think we should allow that to allow the commission to create some kind of system where they can evaluate courses if people want to try to get credit for work they've done before. But I think we have to make the amounts of time the same because they're going to have the same powers, the same responsibilities, the same opportunities that a local broker does. In other words, if I could go to a state that had lesser requirements than Texas and then somehow use that to bootstrap into a Texas license, I don't think that's fair to Texas licensees.
Right. I think that's what Yasmin agreed with the question.
Yeah. Now, and then the other question I have though is, and again, I'm sorry to maybe it's just the time, but of between our meetings, but the issue here is licensing. It's not about commissions. And maybe commissions and referral fees I'm getting confused on, but it's not about getting an out-of-state person paid for a transaction. It's about giving them the right to actually operate as a real estate agent with all the other. It's not just about the money, it's about all the transactional opportunities, the requirements, the rules, the oversight. That's what we're really talking about between portability and referral or commission situations. Is that correct?
I think that's exactly right, Bill. I'm sorry to interrupt, Leslie. I think, Bill, that's exactly right. It's the practice and the regulation. And I just wanted to let you guys know Chair Kestner is on and he is unmuted. So he can speak a little bit about, you know, what the commission is thinking and what was discussed in that meeting with Leslie and him on this concept of reciprocity portability.
All right, thank y'all. Good morning, and sorry I was late. Had a meeting this morning, and then when I logged in, it gave me the way to unmute, but I thought, well, I'm not going to say anything, so I'm not going to write that down, and I guess I should have wrote it down. But reciprocity, this is kind of the way it works. I'm also a licensed broker in New Mexico. I can walk into Georgia and immediately get a license without anything because they have reciprocity. What we kind of discussed on portability is, let's say you have a broker in New Mexico that's been licensed for 15 years and they want a license in Texas. Well, they've probably had Principles 1, Principles 2, law of contracts, probably fair housing, probably financing. But what they haven't had that's so unique in Texas is they have not had agency. We're the only state that does intermediary. They have not had promulgated contracts. And if they're a broker, they probably need to take brokerage. So portability is almost like Leslie was talking about, an education waiver. If you've had law of contracts in any state, basically law of contracts is law of contracts. Where ours is different is the promulgated class where it actually goes in to the Texas 1 to 4. You've had agency in Principles 1, but you haven't had Texas agency. So looking at what education they've had and then requiring either 2 classes or 3 classes or whatever for them to sit and take the test. That's what I'm looking at as more portability or reciprocity. Georgia recognizes every license in the nation except Florida. So if you have a license anywhere in the nation, you can go in there and sell real estate with a Georgia license. I don't think we want that because y'all were talking about you want them to have the education, but I think we can evaluate what education they have and then maybe eliminate a Principles 1, Principles 2, law of contracts and financing and require them to take the true Texas courses. So that's kind of where I define portability versus reciprocity. Hope that helps.
Anyone have any questions or anything to add? So I think we've kind of come to the conclusion we all like the portability idea better. And we all think that you can have an education waiver, but they're still going to be subject to the same requirements that we all had or we all have. And there's not going to be a substantially equivalent deduction for that. If anybody disagrees, speak up. Good. Yay, okay. And so that's something we can address more in the future as well. So, but at least we're all on the same page with that. So that makes us come up to next steps, in which one of our next steps for sure is once again addressing the substantially equivalent for military spouse and what we think that should be and what should be included, and dealing with also the broker license. And if somebody could come in here and have a broker license, like y'all said, or how we figure out how to make that work a little bit better. So that'll be part of our next steps. I think staff is going to look more into Jan's Real Estate License Act question as well. We also thought a good idea, because I know this was brought up in one of our first meetings, our Supplement A for the Qualifying Experience Report. We thought it was a little confusing. We also had talked about taking off like the listing agreement and different things that really we didn't feel like should add up to their points. So we're going to talk about how do we simplify that document? And I'll be sending you a survey and trying to get ideas from all of you. We also want to expand on the broker oversight and responsibility. I know we talked about it today. We got a few suggestions on our last survey. So we need to figure out how we can make our field, or the real estate field in general, a little bit more valuable to the consumer and have better trained agents, and what that looks like as a broker and what that responsibility should be. That also kind of blends in with the competency requirements we talked about earlier today about the geographic competency and how do we define competency. So I think those kind of blend in together as well. And then another subject that we would discuss was the minimum service requirements for some of these companies that are accepting a small fee just to put your listing on MLS, and then they say, okay, the owner is responsible for everything else. Is that really giving them the service that we are supposed to be giving our clients or the general public? And then we're also going to discuss, I believe people wrote about lawsuits.
What is, how much acreage?
1 acre.
So,
I think somebody's not muted.
I muted them.
So we're going to talk about those lawsuits because I believe somebody brought that up in one of our first meetings. There were, I think somebody had wanted to have continuing education requirements brought up, and after speaking to Vanessa, that is more of an ESAC topic, so that's really not part of our charge. So I think we have some great things coming up, and we've laid some groundwork, and hopefully we can keep moving forward on those items. Does everyone agree? Is there anything that someone would like to add, or any thoughts? Bill?
Leslie, oh, go ahead.
If we're just for the future, for future meetings, if we're going to talk about geographic competency, I'm really not clear what the history is and what the rules is on that. And if so, if somebody from the staff could give us sort of some background on that at some point down the road, because I really have a problem with understanding what that's all about.
We can absolutely do that, Bill. And
Great.
I think what we can do, you know, this meeting, I know Leslie and I, when we met, it was kind of the intent was to bring everybody's brains back to what we've been talking about, and to get that path forward. So once we know what it is you guys want to discuss at the next meeting, so for example, that the experience points issue, if that's for the next meeting, then what we as staff can do is we hold these prep meetings to try and get you the information that you will need for that meeting if you want to have a presentation. So for example, geographic competency, do you know, where did that, like you just said, where did that come from? What do we see? Do we get complaints on it? What's our outreach on it? What are some things like that? So once we kind of have that agenda set, I usually end up working with Leslie and whatever sort of subject matter expert we have, be it someone from enforcement, be it Jennifer, Denise. It's almost always Jennifer and Denise on everything, and that way we can answer those questions and bring that to you. So if there's ever anything that you know you need more, you think you would want more staff insight on, please let us know. We are happy to do any of that kind of stuff. So I've written that down on competency, Bill.
One thing I really want everybody to think about before the next meeting is kind of the issues that you're experiencing now with broker oversight, broker responsibility, agents not being trained. That could really help our discussion and figure out how we could go forward better, whether it be outreach within the communities, videos, more requirements, whatever that may be or look like. That's something that we really need to talk about, because I think, I mean, we're at a place now that if we don't improve the quality that the consumer is getting, technology can take us over. So we need to figure out how to make that improvement.
Leslie?
Yes.
One of the things at some point in time I'd like to see us look at again that we had in the last working group, and it got kind of set aside because of the Sunset Commission. We made a distinction between someone who is a broker and someone who's a sponsoring broker. Not a different type of license, but I mean, if you meet the requirements, you can become a broker and day one open up a real estate office and hire people and go through the process and frankly not know anything. We said it's a different level of responsibility. But if you're going to be a sponsoring broker and responsible for people, then maybe there need to be some different requirements. And we kind of made some recommendations and worked through that. I'd really like for us to consider that again in some future meeting, because I think there's a huge distinction between someone who's on their own, if they got a broker's license either in or out of a company, or they choose to be responsible for other people. I think it's a big difference. I'd like to see us at least have a discussion about it.
That sounds good. And I think that could blend in well with the responsibility of brokers.
Yeah. Thank you.
Else?
Leslie, I would add, this is something that Leslie and I talked about, which is that this conversation about the role of the broker, the role of the agent understanding the role of the broker understanding the role of the broker. That is something that I know ESAC is also looking into. And so there may be some cross movement there and some conversations that can be had. And so Jennifer and I are in talks on that too, of keeping you guys up to date with what ESAC is thinking on that and what we're seeing from that, so we can give you a little bit of a report on that, and maybe even get the two chairs in touch with each other.
That would be a great idea. You're reading my mind. So, okay, I guess we're ready to go to, is there any public comment for today's meeting? Vanessa, do you know of any?
No, we do not have anybody that signed up, and we didn't have any written comment. I know we will for the next meeting, so, but not for this one.
Perfect. Okay, the next agenda item is discussion and possible action regarding future agenda items and meeting dates. Does April 14th work for everybody at 10 a.m.? Don't see anybody that it doesn't. Great. Good. I get to see y'all more often now. So I guess that pretty much concludes our meeting, unless somebody has something else to add. So the meeting stands adjourned. The time is 11:45, and the next meeting will be April 14th at 10 a.m. Thank you.
Yeah. Thank you.
Thank you.
Thanks, everyone.
Thank you,
Thank you.
everybody.
Thank